The world as we know it has changed. The U.S. Supreme Court has overturned the Chevron doctrine, marking a significant shift in regulatory litigation. This is not just an alteration of a legal principle, it's a seismic shift that will affect how statutes are written, interpreted, and applied by agencies. The Chevron doctrine, a pillar of administrative law for decades, has been the compass guiding courts in their review of agency interpretations. But in the cases of Loper-Bright v. Raimondo and Relentless v. Department of Commerce, the Supreme Court chose a different path. The court ruled 6-3 that courts must independently assess agency actions under the Administrative Procedure Act, rejecting the two-step framework of the Chevron doctrine. The decision emphasized the court's duty to interpret laws and questioned the reliance on Chevron's ambiguity standard. This overturning did not happen overnight. It was the culmination of years of legal battles and academic debates, a slow but steady buildup to this impactful decision. The shift began with a growing skepticism toward the doctrine, with critics arguing that it gave too much power to administrative agencies. Then came the cases that challenged the doctrine's core principles, each one chipping away at the foundation until the Supreme Court's decision finally toppled it. This monumental decision does not eliminate deference entirely, but it significantly alters its landscape. It shifts the balance of power, giving courts more authority to interpret laws and agencies less leeway to determine their meaning. It also opens the door to potential challenges of past decisions and changes in future regulatory practices. In summary, the Supreme Court's decision to overturn the Chevron doctrine is a landmark move with far-reaching implications. It changes the rules of the game for courts, agencies, and every individual and organization under their jurisdiction. It signals a new era in regulatory litigation, one where the courts hold more power and the ambiguity standard is no longer a given. This is a story of change, of power shifts, and legal revolutions. The overturning of the Chevron doctrine is not just a decision, it's a turning point in the history of administrative law. It will shape the future of regulatory litigation and redefine the relationship between courts and agencies. It's a story that will continue to unfold, and only time will tell the full impact of this groundbreaking decision. This story is not just for law students or legal practitioners. It's a story for everyone, because it affects us all. It's a testament to the ever-changing nature of law and a reminder of the power of judicial decisions. It's a story worth knowing and a story worth telling. So remember this moment, for it marks a significant shift in the legal landscape.